Today's podcast is part 2, the biggest mistakes clients make in responding to interrogatories. And in part 1, we covered some of the major ones. And part 2, we have some different kinds of mistakes that people make. And they're really interesting because some of them are just like you're asking yourself, like, what's going on here? And you just actually can't believe some of the answers that you get. I mean, now one of them is when you're asked to recall a particular incident, particularly if you alleged it in some sort of declaration. For example, on page 109 of this investigation report, you talked about an incident where a supervisor questioned you about your salary, so on and so forth, and you were offended by that. Okay, so tell us what were the exact words that he said, as close as you can say that. I mean, obviously no one is going to recall exact words in any conversation, but they're asking for generally what was it that the guy said, as best as you recall, who was present at the alleged incident, when did it take place, where did it take place? Okay, and an answer I actually got was, well, it was 18 months ago, so I really don't recall. And that was it. Okay, so I'm like, look, if you allege this incident, you got to recall something about it. I mean, otherwise it just looks made up. It looks like you just came up with this, you were upset at the guy or something like that, but obviously you have to do a better job of trying to recall certain key facts in cases. Otherwise, just don't bring the claim. All you have to do at that point is just say, I've decided not to pursue this claim, and the question therefore is irrelevant, and it's not going to lead to the production of any relevant evidence. Therefore, I would object to it on behalf of the client, and that's the end of it. Particularly, you have this if you're suing on hostile work environment, and there might be 20 or 25 things that you say happened. Okay, a defense lawyer, first in interrogatories, then at deposition, is going to ask you for your recollection of each of those things. So they have to be able to cite something about what happened to you. Otherwise, just don't bring the claim. Next, we get to a really interesting concept called similarly situated employees. Okay, what in the world is that? Well, let's say you're disabled and you had typos in some of your emails and you get fired because allegedly you had too many typos in your emails. Okay. Believe it or not, I actually have a case like this, and it's just ridiculous. It's ridiculous that this is why someone gets fired, but we think it's because of disability discrimination. Okay. So very interesting now on this situation. A similarly situated employee is someone who is a co-worker of yours in a wrongful termination case and does not have the protected characteristic that you have. So, for example, this would be a coworker who is not disabled. Then that person did the same conduct that you did. So, for example, that person had too many typos in their emails, and that person did not get fired. That's what we're looking for. And I made a little chart here that can really explain this as you follow along. So, over the top of the chart, we have disability, then we have the typos, then we have was that person fired or not. And we list 5 people. One of them is the person who's suing. Let's call that person Amy. Okay, the second person down, we have Sean, Amy, Nick, Ellen, Elroy. Okay. And Amy's contention is that she had typos, she was disabled, and she was fired, and that really is discrimination. Okay, now, we have made different scenarios here of what would work in a case, what a judge is looking for, what a jury's ultimately looking for, what you should be looking for. Okay, first person let's talk about is Nick, right underneath Amy. Okay. Nick is perfect for a similarly situated employee. Nick is the guy who's going to get you to trial. Why? Because Nick had no disability, as you can see in the column. He had typos, and he wasn't fired. Okay, now that's exactly the opposite of Amy. Amy had the disability, she had the typos, she was fired. Okay, so Amy has the 3 yeses across. Nick has the 2 key no's and the yes that he also had the typos. And you can see that's why someone would think that's discrimination. Because, hey, what's the difference between Nick and Amy? Now, I have a case, this case I mentioned, where the defendant has actually claimed, well, the typos of your guy were worse than the typos of the other guy. Okay, it's an argument. I mean, I don't think a jury would believe that. I can't imagine a judge is going to dismiss a case on summary judgment because of that. But this is really critical, because if you look at some of these other scenarios, they would not work. Okay, so for example, let's talk about Sean, okay? And this scenario would kill your case. Sean has no disability, okay? He has typos and he was fired. What does that suggest? That this is not discrimination, that anybody who's got bad typos or typos at all is fired. That's important to know. You have other people. Let's call this person Ellen. Ellen has a disability. She had no typos. She wasn't fired. Ellen is useless in this case. Nobody cares about Ellen. So when you're asked for who is a similarly situated employee that was treated differently, it's imperative that you understand this chart. You're looking for the no, yes, no, 3 boxes across on this chart. And you can use this chart for clients of mine who are watching this to make sure that you're answering the question correctly. That is really important. Finally, the third thing that I want to talk about today in this podcast is these admissions. I get a lot of questions. I've never seen these before. What in the heck are admissions? And here are some examples of admissions that we have on the screen. Management's reasons for terminating complainant are supported by evidence in the report of investigation. Okay, well, they want you to admit or deny that fact. Okay, obviously, if you admit that's true, you have no case. So you want to go ahead and you want to deny that fact. You don't want to write a whole story in the admission of why you deny the fact or why you admit the fact. And I think this is a big mistake people make, is sometimes they want to talk way more than they need to. All you have to say for this admission demand is deny. Okay, here's another one. Complainant cannot produce any evidence that management's reasons for terminating complainant were different than were articulated in the termination letter. Very simple. All you have to say is deny. I mean, obviously, if you're saying admit, then you know, why'd you bring the case? I mean, whole thing. So all you have to say is just deny. That's it. You don't have to give a speech about it, and you shouldn't. The only time you have to explain your denial is if there's an interrogatory question that says that. That says, if you denied any of the admissions, explain why. Okay, now you get into how many interrogatories does that make? Okay, and this is an issue in law where they're not endless. So generally, you're allowed 25, you're allowed 30. Some judges include subparts. Some judges do not. Some judges will specifically say in their order, a subpart of an interrogatory is a different interrogatory. Some will say it isn't. So you definitely want to consult with your attorney before answering that kind of interrogatory. If you have been the victim of some sort of wrongful termination at work or hostile work environment or something like that, call our office. Or if you're in the middle of litigation, call us. We can help you.